I really wanted to talk about noise because a client of mine, Steve and his wife, are sitting in the back table there, and they brought me a problem about noise coming from the county's animal shelter out on northern Baltimore County. But before I do, following up on what George said, George, number one, is the expert on noise. I want you to know that. So if I make a mistake, he's going to jump up and correct me because I told him to. Number two, in regard to this, the community might be interested in a case that I have that occurred over in the Catonsville area. And a developer contributed to a county council person of that district while they were waiting to have the PUD bill introduced to the county. And the state prosecutor got in because the developer contributed money, not in his own name, but in his employees' names, in the amount of $5,000. Yeah. He divvied the money up amongst his employees, and they contributed. The state prosecutor got involved and created a number. It looked at the number of emails that went back and forth between the parties. As a result of that, he pled guilty to a criminal charge and was sentenced to $50,000, or 55. $58,000. The problem was, it was just the cost of doing business. Because at the same time, I got involved in the case, and I raised it in front of the hearing officer and said they shouldn't get the PUD. They shouldn't get the benefits of the PUD that, in effect, he paid for. Well, the administrative law judge said, oh, this is terrible. It's like how they make sausage. You wouldn't want to know how they make it. You just eat it after it's made. But there's nothing I can do about it. So then it goes to the County Board of Appeals. And the County Board of Appeals says, oh, this is awful. This is terrible. This is an appearance of impropriety, but there's nothing we can do about it. It goes to the circuit court. The circuit court judge simply said, oh, it's the way we do business in Baltimore County, which I thought is rather novel, Goes to the Court of Special Appeals, and they say the same thing. Oh, this is terrible. It certainly is an appearance of impropriety, but there's nothing we can do about it because it's a legislative act of the county council. Well, lo and behold, the Court of Appeals took the case. And I briefed it. I'm waiting for the reply. The oral argument is on May the 4th. And I will be standing up screaming at the Maryland Court of Appeals saying, when is this nonsense going to stop? It's time to stop it. Not only is there an appearance of impropriety, it's demonstrated by the state prosecutor in his statement of facts. And enough is enough. This PUD should be void. This should be the end of it. Not only that, from now on, everybody ought to be told what an appearance of impropriety means. So on that day, we won't know the answer, but I'll get to argue that point. And at some point, it'll be a precedent-setting case for the entire state of Maryland. It will not just apply to Baltimore County, but it's going to be something else. And when that happens, lo and behold, in Prince George's County, Howard County, a bunch of other counties that I'm involved in, they're going to take gas. And hopefully the developers take a bigger dose of gas. Now, let me go back to noise.
But in your cases, you've got a conviction.
Yes.
Well, that's pretty exceptional.
There has never, ever been, from what I can analyze, there has never been a case where the citizens actually have it documented, and not by the citizens, and not by me. It was documented by the state prosecutor. And it aggravated me because I used to be a prosecutor, and I contacted the state prosecutor and asked for any information that I could get while I was trying to try the case. And they sent me a form back that said, no, we can't talk to you, we can't help you. To me, that was not what a state prosecutor was supposed to be. But in any event, it's now at the highest court. Yeah.
Carroll, in addition, that case cost the state prosecutors $220,000 worth of labor charges. And they were appalled because they were only, the developer got fined $50,000.
58,000.
$58,000.
And he wrote his own little addendums on the judge's court order, and he did not, he was supposed to go on probation before judgment for a year. It's gone.
Right, the whole thing is like a joke, and the prosecution was just saying this is the biggest joke around, and it pays to be corrupt because the developer wrote it all off as cost of doing business.
Of course, there was a cost of doing, but $55,000 to go into a multi-million-dollar project. My argument was it should deny, the PUD should be denied. That would be some punishment. But obviously, nobody until now agrees with me, and hopefully the Court of Appeals will. But it's going to be a big case when it finally comes out. But let me get back. Yeah.
One of the interesting aspects of this is we haven't heard a word from any of our elected officials.
Well, as a former council person, I don't know what to say about the councilman.
You would think there would be some kind of reaction, and isn't this horrible?
Well, as a matter of fact, that's only half of the story. The other half of the story is that another councilman running for office actually was gaining money through contributions. And your first district councilman said, I need more money because the other councilman is making more in contributions than I am. Oh, this is going to be fun for me to argue. It really will be. In any event, in any event.
Are any of the opinions published or?
Oh yeah, they're all published. Yeah.
You look up the court order.
Court of Special Appeals is, the Circuit Court is, etc. Yeah.
Not only is it published, I believe they archive videos on their website of arguments.
Well, they will have video that you can tune into for May the 4th to watch the argument. So you'll see what kind of questions I get and how well I handle them or fumble them or whatever happens. But I can't wait because I am old enough that I'm probably older than most of the judges, and I don't really give a damn anymore if they get upset at me. So I'm going to say what I feel, and it may not be a lot of legal argument, but it's going to be a lot of feeling as to this has to stop. This kind of conduct has to stop. And the circuit court judge who said, oh, it's just the normal way we do business.
What's that judge's name?
Yeah, what was that judge's name?
I can't give it to you right now.
Why not?
You can get it, just get the file.
What's the name of the case?
Yeah.
Kenwood Gardens
And Steve Whalen.
versus Steve Whalen.
Okay.
All right, let me go back to noise because this is probably more interesting to a number of different community associations and people. In the old days, I would fight windmill noise, I would fight machinery noise, I would fight in First District, New England Motor Freight, we had a noise issue with the trucks backing up, beeping, making noise, unusual type noise. And we were very successful in stopping New England Motor Freight. We were successful in stopping some of the windmills that were proposed in northern Baltimore County before the legislation took effect. And this guy right here is the one that worked for the state and did noise analysis and noise investigations and enforcement. When he retired, and I learned this from him, when he retired, basically the state, while keeping the noise decibel readings, and I hope I'm right on that, 65 dBs during the day, 55 at night, and 5 below whatever it was for an unusual type of noise that was a spontaneous, etc. And there was a definition for that. The state did keep that, but they dropped the enforcement people. So George wrote a letter to the state government and said the counties should pick it up. Well, some counties did, and George has provided me with a couple of their legislation for noise. But Baltimore County didn't seem to pick up the enforcement of, quote, noise issues. And he and I and Steve back there looked through the county code, and we can't find under noise. There's lots of stuff under noise in the county code, but there's nothing about enforcement of noise and who does it, okay? So I'm sitting here a couple weeks ago when Steve came in, trying to figure out how we do it, how we administratively get citizens to be able to not have to file a lawsuit in circuit court, because A, that's expensive, B, that's difficult, C, you're liable to get thrown out if you don't have something else. So the better way to do it is go through the administrative process, meaning file some sort of complaint, have it inspected, have a hearing, have the county determine whether it is really a bad noise or a good noise or whatever, and then be able to appeal that decision through the administrative process to the Board of Appeals, and then ultimately to the court. And it comes in as a judicial review. So you don't have to lay out all the money at first. You don't have to have your whole case put together. You don't have to go through discovery. You don't have to answer interrogatories. So there's a lot of financial savings if you go through that administrative process rather than just, oh, let's sue them in court. So I happened to be talking to one of the hearing examiners in the county, and I complained to him. This was not during a case. It was just, I happened to meet him in the hallway. And he says, oh, that's not under noise, it's under nuisance. So I looked in the nuisance section of the county code. And here's what it says. And if you need to write this down, County Code 13-7-101, that's the definition. And then 13-7111 is nuisance on private property. Well, that seems to fit the definition of what we're concerned about, Steve's neighborhood is concerned about. So that means someone on their private property are doing something that affects the noise, the state level of noise. And the county is supposed to, with such a complaint from the community, is supposed to issue a notice to abate, if in fact the community can establish that it is in violation. Now maybe the county also has an inspector who can go and use the technical equipment that they use, whatever that may be, since I'm a lawyer and not a technician, and they can determine what the decibel rating is. They can cite the property owner, the homeowner, and then the homeowner can ask for a hearing. That raises a good question. Can the person who complained about it, can that person ask for a hearing? And that's a question mark in my mind that I haven't had ability to research yet. They then have a hearing, and that hearing could be appealed all the way to Annapolis at the Court of Special Appeals. The county also can abate the hearing, the noise violation itself. They could cite a civil penalty, or they can ask the Department of the Environment to enforce it, meaning go in and stop the problem. Now, if that was some neighbor creating raucous noise to you, and you wanted it stopped, it could be like a bar, it could be something else, some other type of activity, or New England Motor Freight where the trucks were beeping and making noise in the middle of the night. That process could work. In our case, it turns out that the animal shelter is the county's own animal shelter. So that's going to be an interesting question. Can we force the county to go through this process in violation of the state law? And that's a question I haven't had time to research yet. But I told Alan, I said, I just wanted to let everybody know that there apparently is, contrary to what I originally thought, there is under nuisance claims, a nuisance filing, a way to try to stop an annoyance to you and get the county to initiate it, and then you can subsequently follow it up. So that's really all I have to say. Any questions?
So right now they moved the North Point precinct from Merritt Boulevard over to Eastwood, and they have to set off the alarms 3 times a day before the officers go out. So that means that they're doing it in the middle of the night, things of that nature. So you talk about having a case that dealt with the county having an area. So this is another case.
Yeah,
So-
you have you have the same problem that the animal control people have, or we have with them. It's going to see whether or not that's something. And again, maybe we could ask this expert here, but if it does violate the state law, can we then proceed against the county or the police department? And he says,
State law supersede county law?
No, I think when they repealed the old enforcement clause, they made it very clear that the state would not take any enforcement action, and that was going to be the responsibility of the county. But they never changed the word, any words that I recommended, taking out may and putting in shall. They left it in as may.
but there's another aspect to that problem, and the aspect is it's a state law that says it shall not be more than 65 dBs.
You lawyers are going to get more money.
No, but it seems to me I would argue that even the county can't violate state law.
State law supersedes.
And we'll see how Mr. Kamenetz reacts. He knows I bother him all the time. Yeah.
Is it possible that there is legislation that would include light?
Light pollution.
Yeah. I used to represent clients along Reisterstown Road where the various automobile dealers have these big tall lights. And I can't remember now, this has been 10, 15 years ago, there is a light statute, and I can't remember whether it was under the state or the county. I can't remember, but
There's a specific building in Timonium that used to have the University of Phoenix.
right.
And then when the University of Phoenix left, New York Light got to have their name in lights. And it's a nuisance to the neighborhoods that are on the other side of 83. And when that building in particular was built, it was built with a very highly reflective glass that is just an absolute eyesore. And our communities did not have an opportunity to be heard in respect to that type of building being built, because we weren't part of that particular.
Well, most of the light cases that I've had are, for instance, from car dealerships where their lights and their towers shine into somebody's bedroom. I mean, I literally, in Reisterstown Road, I had one where the lady in her bedroom and in her living room, the light was so bright all night long, and we were able to get that changed. We were able to win that. It's just been so long on the light issue. But I know the county requires the lights to be directed down to stay on the property and not go beyond the property's boundaries. And so light has been a lot of light problems have been resolved. Now, I don't know about that particular one. But anyway, yeah.
And how many of the cases that deal with noise would you say that the, let's say the public is able to win? Is there any kind of percentage that?
I've won them all. But I've only had 2 or 3.
Okay, well, that's still a great record.
It's 100% right there.
Right. We stopped New England Motor Freight, that case, and that had, George, I think, actually testified in that case, testified for me. I stopped the tower, the fan out, the wind turbine out in northern Baltimore County, and I stopped another one further north and west. So those are the only 3 that I had.